So at long last, the Trump administration is going to the Supreme Court with a major court case. And this has to do with the RIF, reduction in force. So I'm not going to go into too much detail because what you're about to watch, it goes into an immense amount of detail. But basically, this is the Trump administration seeking relief from the Supreme Court to proceed with its lawful reduction in force. Here you go. All right, so just starting right off the rip, you can see how this is President Donald Trump et al. Applicants. So you'll see in a little bit, there are a lot of applicants that go along with President Donald Trump on this. And of course, it's against the American Federation of Government Employees, AFL-CIO et al. And again, you'll see there's a long list of agencies that the Trump administration is filing against. So it was initially, or I should say, President Trump, as I mentioned in the introduction, came up with a reduction in force, and that was very shortly thereafter blocked by a district court out of the Northern District of California, and here we are. So they've gone back and forth a little bit, and now it's gotten to the point where the Trump administration is asking the Supreme Court to take up the case. So if we scroll down a little bit, the first thing I wanted to highlight was the number of applicants. And you can see what's highlighted in yellow going all the way down to Elon Musk. I mean, this encompasses Secretary of Agriculture, Department of Commerce, et cetera, et cetera, et cetera. Those are the entities that are filing with the Supreme Court against the folks that are saying, hey, we don't agree with this reduction in force. So they're the respondents or the plaintiffs. Of course, the AFL-CIO is mentioned. And again, it's an extensive list. The Northeast Organic Farming Association, Inc., Vote Vets Action Fund, Inc., and on and on and on. The gist of the matter is really quite simple. Basically, the president came into office determined to trim the size of the federal government. And when he did that, he was blocked by this district court. And you'll see right there, barring nearly the entire executive branch, 19 agency, 11 cabinet departments from implementing an executive order that directs agencies to prepare plans to execute lawful, emphasis on the word lawful, reductions in the size of the federal workforce. So that's really what we're talking about here. The president would like to conduct a lawful reduction in force, and he is being blocked by a district court. Now, the defense for the government side is extensive. And we're going to notice in a little bit, this isn't the first time a president has decided to ask his different agencies to create a RIF or reduction in force. The Clinton administration did that. But be that as it may, the Constitution does not erect a presumption against presidential control of agency staffing, and the president does not need special permission from Congress to execute or exercise core Article 2 powers. This is an important point because not long after President Trump did this, you may remember, people saying, oh my gosh, he needs to be impeached. And one of the reasons they wanted to impeach him was because of this whole reduction in force. Well, quite clearly, the Article 2 powers granted to the president give him the right to do a reduction of force. Be that as it may, moving on down, the district court erroneously concluded that the executive's actions likely violate separation of powers. That's what I was just talking about, and that is absolutely not the case. The court, referring to the Supreme Court, recently intervened to stop another district court from undoing the effects of the lawful large-scale termination of probationary government employees. So what the president and his team are saying is, listen, Supreme Court, it's not the first time we've had a district court overstep their bounds. They're doing it again. You, as the Supreme Court, granted us permission to terminate probationary government employees. It's the same thing, just dressed up slightly differently. We need your help so we can proceed with the reduction in force. And you'll notice this part right here is interesting. So, and it's going to tap into President Clinton that I mentioned earlier. So for at least about 150 years, Congress has recognized the executive branch's authority to carry out reductions in its workforce as the need arises, subject to statutory preferences for veteran status and other factors. So basically what they're saying is, we've been doing this, Supreme Court. These reduction in forces happen as situations change and different situations arise. We've been doing this. We just need permission to do it again. We're being blocked by a district court. Please help override their decision so we can proceed with the reduction of force. Then the executive has repeatedly exercised RIF authority. 1993, for example, President Clinton ordered all federal agencies with more than 100 employees to eliminate not less than 4% of their civilian personnel positions within 3 years. So we hear this, and it's a little bit mind-boggling to me. Coincidentally, I was in the military when President Clinton was doing this reduction in force, and I find it quite ironic that we lived through that without opposition. He's the president; he wants to do a reduction in force. We downsize, we figure out how to move on. But he, as the president, in this case President Clinton, had the right to do that. And how ironic is it that I'm out of the military? We have a Republican president trying to do the same thing that a Democrat president did, and he's being told he can't do it. So anyway, the history, 150 years worth, and the specific examples, quite impressive. I would like to think that the Supreme Court is going to agree with the Trump administration so we can move on with a reduction of force. But the way things are going, especially with Amy Coney Bryant, she seems to be not as conservative as we may have thought. And then, of course, there's Gorsuch and Kavanaugh. We can rely on Alito and Clarence Thomas. It's the other three. And then, of course, there's Chief Justice Roberts. Who knows? Hopefully, these people can simply follow history and examples in the not too distant past where the president was allowed to do a reduction of force, make a quick decision, and we can get on with this thing. But nonetheless, scrolling down, this is just a little bit of background on why the court, and when they say the court, they're referring to the Supreme Court, not the district court that blocked this whole thing. So they're saying this court, meaning the Supreme Court, should stay the district court's injunction, which suffers from multiple fatal flaws. It's really strong wording, and I put this video up here so everybody can actually read it. I'm going to scroll through it, obviously. But one thing you'll notice is how many times the Trump administration has referenced previous cases. There's a lot of case law which supports the position of the Trump administration against this district court in Northern California. But at any rate, point one, RIFs are indisputably permitted by federal law. Obviously, we've had them in the past. We're trying to do another one, and I'm sure there'll be a Democrat president that does them in the future without objection. Anyway, point two, the executive order directs preparation of RIFs only as consistent with applicable law, which is important to note. The district court would like to lead people to believe that the Trump administration is doing something outside the bounds of law, and that is absolutely not the case. And from a separation of power standpoint, which you've heard and I mentioned earlier, Article 2 powers granted to the president. He absolutely has the authority to do a RIF, reduction of force. And then point three, many of the RIFs have not been finalized. And point four, any challenges to the RIFs themselves are channeled into specialized administrative and judicial review schemes concerning federal employees under the Civil Service Reform Act. What they're getting at is, and of course, the Federal Service Labor Management Relations Statute. What they're saying is we haven't even formalized exactly what we're going to do and how many people we are going to let go. It can't even get to that point of setting this thing into motion. It's like we can't even go past the stop sign. Beyond that, the Trump administration is acknowledging that when they assume they get permission to do this reduction in force, when they do that, any challenges should be channeled through the appropriate channels. So it's basically saying federal employees have the right to contact, as per the Civil Services Reform Act, whoever they need to contact. But we haven't even gotten to that point yet. But nonetheless, the important thing to note is that the Trump administration is certainly trying to do this lawfully. And any and all federal employees will, of course, have their chance to follow the proper channels if and when they individually get impacted. Then substantially or substantively, substantively, moreover, the general direction and guidance contained in the executive order memo are unquestionably lawful. Just mentioning again, it's not as if they're going outside the bounds of the law, they being the Trump administration. And they're referencing again and again prior cases where the president, Article 2 of powers, was allowed to conduct a reduction of force. Equally meritless. And what they're talking about, the Trump administration is saying the district court is meritless. So equally meritless is the district court's objection that the president may not, without Congress, fundamentally reorganize the federal agencies. This is what I was talking about earlier when you had this, or these people, in this case, the federal, there's a district court, but it's not just the district court. It's people that want to impeach President Trump because they're saying he can't do this without Congress. And that's just fundamentally not true at all in any way, shape, or form, nor is it consistent with history to say the president can't do this. That they do not eliminate any subcomponents that are statutorily required or prevent the performance of functions that are mandated by statute or other law. Getting back to what we were talking about before, we're doing this, the Trump administration is trying to do this lawfully within the confines of the law, but we can't even get past a stop sign to start doing it. Hence, it's going to the Supreme Court. Exacerbating matters, the district court joined the parade of courts entering improper universal injunctions, extending relief far beyond what was necessary to redress respondents' alleged injuries. Nobody's been injured yet because nobody's been riffed. It hasn't even started yet. But what the Trump administration is alluding to is these district courts creating nationwide injunctions, which are not what they're supposed to be doing. That is an overstep that we've seen again and again and again. And certainly we see it in this case. So that abuse of equitable powers alone calls for a stay. That's that sentence right at the end of the area highlighted in yellow. And they're right in that case. What they're saying is we have, as per the Constitution, the right to do this. The district courts do not have the right in any way, shape, or form to do what they are doing by creating a nationwide injunction and stopping the president from doing something he was lawfully able to do. And as we scroll down, you can see, amongst other things, how many times they're referencing prior case data. There's another one right there. There's another one right there. And I'm hoping that the Supreme Court has done their homework in the background. For me, it's really good to see that the Trump administration has taken a lot of time to write this. This block by the district court happens quite some time ago. And I was wondering, what is going on with this? Are they going to appeal to the Supreme Court? How long is that going to take? Well, I think part of the answer to that question is they really, meaning the Trump administration and the attorneys for the Trump administration, has spent a lot of time documenting as best as they can to make this as clean cut or clear cut for the Supreme Court to decide in favor of the Trump administration. And then on February 11, 2025, President Trump issued an executive order seeking, like President Clinton's order, to reduce the size of the federal government through RIFs. So it's just putting a time on this. Here we are. This is the beginning of June. By the time you see this video, it'll still be within the first week of June. This executive order happened on February 11th. So March, April, May. It's unbelievable how many months this district court in California has been able to delay the RIF, but hopefully we're about to come to an end of it. And again, the Trump administration's legal team is referencing President Clinton's order, which was the same thing, just as President Clinton saw at that time, a necessary reduction in force. I won't scroll quite so quickly so you can see all this, but they just go into more detail about what happened in the past and basically documenting cases that support the point the Trump administration's legal team is trying to make. And as you can see, it's quite detailed. It's also going over in detail the going back and forth between the Trump administration and the district court and how we ultimately ended up to where we are, the Trump administration filing with the Supreme Court for relief. It's just an incredible amount of detail. And really for me, and hopefully for many of you, it's fascinating to read how this works. Now, here we go. On May 30th, 2025, the ninth Circuit denied applicant's stay motion by the 2-1 vote. So again, we're in the beginning of June. This just recently happened. And that again gets to why the Trump administration is going to the Supreme Court saying, okay, it's time for the Supreme Court to get involved. We need relief. When you get to the argument section, it's kind of fascinating because you can really understand. It's almost like you can insert yourself into the hearings that'll be held at the Supreme Court to understand exactly what these statements are going to be from the legal team from the Trump administration. So, point one, this court should stay the district court's order enjoining implementation of the executive order and memo. And then they're going to go into a lot of details why. The government is likely to succeed on the merits. Respondents' claims were not justiciable in district court. What they're saying is this isn't a district court decision, it's overstepping its bounds. And then getting down to more points that the Trump administration is trying to make in quite some detail. It's going to be fascinating to watch this thing unfold. I wish I could be a fly on the wall at the Supreme Court and just listen to the back and forth. But the amount of work that's gone into actually creating this is pretty impressive. Not just the work, but all the detail that went into bringing this ultimately to the Supreme Court. And hopefully the Supreme Court is already thinking in favor of the Trump administration, not because of any other reason than just like it says right there, respondents' claims are meritless. I mean, this is a pretty clean cut case based upon a lot of prior case data, court data, as well as the history with the Clinton administration and that administration's reduction in force. And you can see how many points they're trying to make. The memo is similarly sound. They're talking about RIF plans that should seek to achieve, et cetera, et cetera. Then when we get finally down to this part, almost like a summary, not quite there yet, but this is worth reading. Most egregiously, the district court treated as evidence of unlawful action. And they're bringing evidence and unlawful action into quotations because they're questioning that, meaning the Trump administration's legal team is questioning that because what evidence and what unlawful action? The prospect that the agencies are acting at the direction of the president and his team in planning and executing RIFs. Likewise, the Court of Appeals asserted that the critical question is not whether Congress has directed the agencies to engage in large-scale reductions in force, but whether Congress has authorized the president to direct the agencies to do so. The lower court's view turns Article 2 upside down for the reasons set forth above. So again, think of it like a chain of command. It goes from the president to the agencies, not as the lower court is saying, from the agencies to the president. So it's going to be, the hearing at the Supreme Court will be quite interesting because the lower court's literally trying to turn Article 2 upside down, meaning they're trying to take the powers granted to the president by the Constitution to do a reduction force, say, nope, you can't do that. Congress has got to tell you what to do. It just doesn't make sense. The courts articulated no reason why agency RIFs would somehow be exempt from the fundamental constitutional principle that the president, as the repository of the entire executive power, may direct his subordinates in exercising their lawful actions, again, citing court cases. Contrary to the lower court's suggestions, applicants have never denied that agencies are acting at the ultimate direction of the president. That, of course, is the way the constitutional structure is meant to work. The court's treatment of such presidential direction as smoking gun evidence of illegality was deeply mistaken, and they are absolutely correct to say that. And it really kind of speaks to just how outrageous some of these district courts are with their rulings and how much power they actually have. We really need to, as a country, whatever side you're on, we really need the Supreme Court to step in and add clarity and kind of get us on the right track again. And hopefully they do it the right way and make the right decision in favor of the Trump administration. This is worth discussing for a minute as well. At a minimum, the injunction is overbroad. Not overboard, overbroad. So it says this court should independently stay the injunction. They're referring to, when they say this court, the Supreme Court should independently stay the injunction due to its indefensible scope. It sweeps far more broadly than is necessary or permissible. This court, meaning the Supreme Court, has repeatedly enunciated the constitutional and equitable principle that relief must be limited to addressing this specific plaintiff's injury. So what they're talking about is what I was mentioning earlier, that the district court has turned this into a national injunction, and that is beyond the scope of what they should be able to do. And just more and more examples of court cases. I mean, I shouldn't say every page, I'm being overly dramatic, but almost every page is referencing case after case after case that supports the Trump administration's decision. Then this section is interesting. The district court's order inflicts irreparable harm on the government and the public interest. So what the Trump administration is saying is this little district court in Northern California has brought everything to a screeching halt. You remember the executive order was back in February. Here we are in June. So it's stating the government is also being significantly and irreparably harmed by the preliminary injunction, and those harms outweigh those asserted by respondents. The injunction strikes a critical governmental interest by barring the implementation of agency RIFs, reduction in force, pursuant to the executive order and memo, and hampering agencies' control over their own administration. Again, referencing a prior case. As this Supreme Court has observed, the government has traditionally been granted the widest latitude in personnel matters. So simply saying that, hey, as the executive branch under Article 2 powers, we have the power to conduct a reduction of force, and we need you as a Supreme Court to just reassert the fact with numerous prior court cases, the Clinton administration's RIF. We just need you as a Supreme Court to allow us as the federal government, as the executive branch, to direct the agencies to proceed with reduction of force. More concretely, the injunction's immediate consequences are stark. The injunction has disrupted and brought to a halt a complex government-wide effort, which began with the president's executive order more than 3 months ago, that's back in February, to prepare for and execute agency RIFs, reduction in force. It enjoins more than 20 executive branch entities and any other individuals acting under their authority or the authority of the president from further implementing the executive order and memo, including by carrying out any existing RIF notice or approving and issuing any new RIF notices. So what they're saying is everything's been brought to a screeching halt, and we really don't know what to do. And it's not just the Trump administration. You kind of got to sympathize a bit with the federal employees. Are they going to have a job? Are they not going to have a job? Do they need to look for a job? I mean, what are they doing? Do I wait to get fired and get some sort of a separation bonus? I mean, they don't know what to do. The inevitable consequences is to compel federal agencies to keep large numbers of employees on the payroll without necessity at unrecoverable taxpayer expense, thereby frustrating the government's effort to impose budgetary discipline and build a more efficient workforce, which is the point I was making a little bit earlier. The Trump administration is trying to trim expenses of a very, very large federal government. And we can't get this money back. No offense to the federal employees, but they continue to be paid at our expense. We're all contributing to it, and it is very, very expensive. So scrolling down, you can see just, case example after case example after case example. It's incredible how much detail is actually in this. The administrative stay, is warranted. And then in conclusion, the court should stay the district court's May 22nd order enjoining the executive order and memo. In addition, the Solicitor General respectfully requests an immediate administrative stay of the district court's order pending the court's consideration of this application. Signed, Solicitor General. So basically what they're saying is, listen, just put a stay on this thing. I know it's going to take you time to prepare, but we need some sort of a relief because this has been going on or not going on since February, and it's time to get to business. So we will see what happens with all this. And I'm really curious to see your comments below, what you think about it. The Supreme Court has been extremely busy with case after case. This one is extremely important, not to take away from the others, but this gets to separation of powers. It gets to Article 2, how much power does the president have? But it's getting to a more fundamental issue, and that is obstructionism. And I know there are Democrats that are going to say we have separation of powers. I don't know how to make it more clear. If you actually read the Constitution, if you read case law, this specific case has nothing to do with an abuse of separation of powers. President Trump, as was President Clinton, are perfectly within the rights to do a reduction in force. So it's getting to something more significant, which is obstructionism on the part of the Democrat Party. And we see it everywhere. We see it with violent criminal illegal aliens and how hard it is to deport these people. They cry lack of due process. I did a separate video on due process, and they are being given due process. It's really judicial obstruction, or I should say the judges primarily on the Democrat side obstructing the ability of the president to lawfully, emphasize on the word lawfully, to conduct what he is allowed to do as per the Constitution. It truly is obstructionism, and that is a problem. It's almost as if the Democrats lost the election. They lost the president, they lost the House, and they lost the Senate. But they are still trying to exert control contrary to the will of the people. And that is a fundamental problem. That's something we're not talking about enough. The Democrats are literally trying to use judges to override the constitutional right of the president. Let me know down in the comments what you think about that. I'd really like to get that conversation going back and forth and try to keep it as fact-based as we can. I really hope you enjoyed the video and got a lot out of it. And by all means, scroll through it, look at all the case data. There's a heck of a lot of information to read. Hopefully, it was a benefit to you. It certainly is fascinating to me to just watch how this thing unfolds. Again, we've been waiting for this for a long time, but it sounds like we're finally going to make it to the Supreme Court, and we shall see what happens. Let me can't even talk. Let me know down in the comments below what you think is going to happen. Do you believe the Trump administration has the right to do this reduction in force? Do you believe it's being done lawfully? Do you agree that the executive branch under Article 2 of the Constitution has the right to do a reduction in force? Because it seems like many of you do not believe the Trump administration can do this, even though the Constitution says he can, and prior administrations, as in the Clinton administration, did the same exact thing. Let me know what you think down in the comments below. Enjoy the video, thumbs up. Want to see more like this, subscribe, share it with people you think are interested in it. Again, let's get comments going down in the comments section. As always, until next time, God bless. Love you all.